This is a Climate Emergency Institute video. This video covers a historic legal hearing that occurred on the 4th of June 2019. The hearing was before the Ninth Circuit Court of Appeal of the United States, and the case was heard in Portland, Oregon. Who is Juliana? Juliana is Kelsey Cascadia Rose Juliana, and she is the first cited plaintiff in what is already a historic legal case in the United States. The case is Juliana et al. And a number of other plaintiffs who are all young people, and they have brought the case against the United States of America et al. So that's other heads and departments of the government of the United States of America, as well as two presidents of the USA. This case is under our Children's Trust in the United States, and their mission is securing the legal right to a safe climate and a healthy atmosphere for all present and future generations. They are our best chance for a healthy atmosphere and a safe climate for all of us, so I would encourage everybody to support our Children's Trust. The children, the young people, want climate justice, and they've gone to the court to try and obtain it. So the 2015 Juliana versus United States of America, it's a lawsuit against the U.S. government, and it's brought by 21 youth plaintiffs. This case was brought to the district court in Oregon 2015, and it was brought against several of the United States executive branch positions and officers, including President Donald Trump and including the former President Barack Obama, and both disputed the case and attempted to have the case dismissed. In 2016, United States District Court of Oregon Chief Justice Ann Aitken, in responding to a claim from the United States government that the case be dismissed, found against the government and for the young plaintiffs in a 50-page ruling which upheld their claim that a stable climate was a fundamental right, and so allowing the case to proceed. Within the document, she stated, a stable climate system is quite literally the foundation of society, without which there would be neither civilization nor progress. And that, in absolutely every way, is totally correct, of course. In this document, Judge Aitken notes that for the purposes of this motion, I proceed on the understanding that climate change exists. She goes on to say that defendants, that's the United States government, had opened their objections, that's to a previous claim by the U.S. government that the case should not be heard, should be rejected. The government had said climate change poses a monumental threat to Americans' health and welfare by driving long-lasting changes in our climate, leading to an array of severe negative effects which will worsen over time. The existence of climate change is not disputed in this case. The seriousness is not disputed. The fact that it's caused by human activity is not disputed, and that it's going to get worse over time. None of that is disputed in this case. What the government says is that the young people are not afforded and have no right to any protection from the government of these impacts of global climate change. Wow. There was another surprising twist to this case in that Judge Aitken let President Trump, the United States' most aggressive fossil fuel promoting and climate change denying president off the hook, at least for now. In dismissing this petition from the Trump government to dismiss the case, Judge Aitken said she was not changing her mind to allow the claim's constitutional claim. She cited her prior decision that said, where a complaint alleges Knowing government action is affirmatively and substantially damaging the climate system in a way that will cause human deaths, shortening human lifespans, result in widespread damage to property, threaten human food sources, and dramatically alter the planet's ecosystem. This is a claim for a due process violation. After 3 years of legal delaying by the U.S. government, the case was approved by the Ninth Circuit Court of Appeals, and it was booked for an October 2018 District Court trial. But a last-minute emergency intervention by the United States government to the Supreme Court to have the Supreme Court deny the case even before trial put it on hold again. In November of 2018, the court refused to grant the Trump administration's plea to stop the case before trial, but what it did was it sent it back to the U.S. Court of Appeals for the Ninth Circuit again, and that's why it was put on hold again. On the 4th of June, 3 judges for the Ninth Circuit heard arguments from both sides yet again. And here are some of the young people plaintiffs who have taken the United States government to court to try and secure a safe climate for themselves. And as I say, they really are doing this on behalf of everybody now. The chief counsel for Our Children's Trust for the plaintiffs is Julia Olson. And in her summation, she said, "When our great-grandchildren look back on the 21st century, they will see that government-sanctioned climate destruction was the constitutional issue of this century, and really for all time." Now, here is content, amazing content, from the application made in 2015 by the Our Children's Trust. In response, in December 1990, that's in response to a request by Congress, 1990, the EPA submitted a report to Congress on policy options for stabilizing the global climate. The EPA's 1990 report concluded, responses to the greenhouse problem that are undertaken now will be felt for decades in the future, and lack of action now will similarly bequeath climate change for future generations. And so here we are in 2019 with the young people of the United States arguing for them to have a safe climate and for all future generations. The EPA's 1990 report called for a 50% reduction in total U.S. carbon dioxide emissions below 1990 levels by 2025. The EPA explained that such reductions were the only pathway to achieve Congress's goal of stopping global warming and stabilizing the climate system. I'll repeat that. Congress's goal of stopping global warming and stabilizing the climate system. And even more amazing, listen to this. The EPA's 1990 report called for stabilizing atmospheric CO2 concentrations at 350 parts per million, the current level at that time, in a response to the congressional objective that total global warming not exceed 1.5 degrees C above the pre-industrial level. My God, 1.5 degrees C recommended by the United States Congress in 1990. And we have, as the world, we have only just gotten the 1.5 degrees C limit approved after the 2018 IPCC Intergovernmental Panel on Climate Change's special report on 1.5 degrees C. And today, atmospheric carbon dioxide concentration is 410 parts per million. And we have 350.org to remind us that 350 is the safety limit. We are way past the danger limit today. In its 1990 report, the EPA confirmed the executive branch's findings from 1965 that carbon dioxide was a dangerous pollutant. And as you hear, That was only reaffirmed by the EPA in 2009. The Office of Technology, they issued a report stated to Congress stating that major reductions of carbon dioxide would require significant new initiatives by the federal government that must be sustained over decades, even before all the scientific certainties are resolved. It is clear that a decision to limit emissions cannot wait the time when full impacts are evident, and that time is today. The lag time, which is something that I've tried to communicate for many years, between emission of the gases and their full impact is on the order of decades to centuries. Some of the impacts take decades to fully impact, but some take centuries, like sea level rising. So too is the time needed to reverse any effects. So what they're saying is there's a long lag between emissions and the impacts of global warming and climate disruption, and so action must be taken long before that time. And here we are, and everybody knows we're experiencing disastrous impacts driven by climate disruption all over the world. The 1991 report informed Congress that the level of emission reductions needed would require the country to wean itself from fossil fuels. 1991, a U.S. department advising Congress that to obtain climate safety to avoid catastrophic danger, the United States had to wean itself from fossil fuels. Today, in 2019, the United States is extracting and distributing more fossil fuels than ever, concluding that actions would be required across the federal government. Both the EPA 1990 report and the Office of Technology 1991 report concluded that an essential component of reducing CO2 emissions was implementing a rising carbon tax, and we are still fighting for a carbon tax. The recommendations of the 1990 report and the 1991 report, changing by degrees steps to reduce greenhouse gases, of course, as we know, were never implemented. United States fossil fuel production, consumption, and combustion all continued to accelerate at dangerous speeds for decades, and presently faster than ever. In 2009, nearly 17 years after the United States ratified the UN Convention, the administrator of the EPA issued EPA's formal, it's a repeat, endangerment finding under the Clean Air Act. Now this is most important. The findings stated that current and projected atmospheric concentrations of greenhouse gases, including in particular CO2, threaten the public health and welfare of current and future generations. Now, the atmospheric concentration of CO2 in 2009 was 386 ppm. So this says formally that in 2009 we had exceeded the danger limit under the United Nations Convention on Climate Change of 1992. I remember reading this endangerment finding by the EPA in 2009. It was very comprehensive. It was a long document, a long report. However, EPA, and I didn't know this, issued its endangerment determination only after being compelled to do so by the United States Supreme Court in Massachusetts. So that covers some really interesting and significant material from the young people plaintiffs. So now we come to the other side, the most recent attempt by the United States government to have the case dismissed even before it goes to trial. This is from the appellant's opening brief, so that's the government of the United States of America. So look, they claim, the government of the United States claim there is no fundamental right to a stable climate system, that no federal public trust doctrine creates a right to particular climate conditions, and I'll get to this a little later on, and that any public trust doctrine would not apply to the climate system or the atmosphere. What legalistic absolute nonsense. What the legal experts say about the public trust doctrine for the USA is that the public trust doctrine, which has been part of American jurisprudence since the founding of the country, provides that a government holds essential natural resources in trust for present and future generations. These resources include the sea, navigable rivers, and the atmosphere. The public trust doctrine requires that the government protect the nation's natural resources. The failure to control carbon emissions imperils those resources in a truly unprecedented way. Ocean acidification, melting ice caps and ice sheets, biodiversity loss, and extreme weather events, caused in part by man-made carbon emissions, all impact essential public resources that the United States officials have a duty to protect for the sake of successive generations. United States law over a long period of time, in fact, strongly supports the public trust doctrine, and it is all documented in this legal book, Nature's Trust, by Mary Christina Wood, which was published in 2013. It's all in there. Now, the government's lawyer made a big point of his accusation that the young people, the young plaintiffs from our Children's Trust, were attacking the American Constitution. He used the word attack several times in the opening of his presentation to the Ninth Circuit judges. I'm not a lawyer. I do have a background in environmental health protection policy, but I had to go back to look up some pretty basic stuff on the United States Constitution. 1776 United States Declaration of Independence, that's a long, long time ago, is the statement adopted by the Second Continental Congress meeting on July the 4th, 1776. This one is famous for the following: "We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness." The U.S. Constitution came into force later in 1789, and it's been amended 27 times, that being in order to meet the needs of a nation that has profoundly changed since the 18th century. I found it interesting that the Constitution opens with the following: "We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity," that means to future generations, "do ordain and establish this Constitution for the United States." So, in general, the first 10 amendments, which came rapidly, are known collectively as the Bill of Rights as part of the Constitution, and they offer specific protections of individual liberty and justice and place restrictions on the powers of government. The Fifth Amendment, which was cited in our legal case here, has the following provision: "No person shall be deprived of life, liberty, or property." And I also found the 1789 Ninth Amendment interesting. It says that the enumeration in the Constitution of certain rights shall not be construed to deny or disparage other rights retained by the people. So this formally states that the people retain rights absent specific enumeration in the Constitution. Going over the court documents, I found that the lawyers for our Children's Trust did in fact cite the Fifth Amendment and also the Ninth Amendment in their case that the young people, the plaintiffs, are suffering violations to their clearly stated rights under the United States Constitution. They claim that there is no fundamental right to a stable climate system. What they say is the Supreme Court has regularly observed that the Due Process Clause specially protects those fundamental rights and liberties which are, objectively, quote, deeply rooted in this nation's history and tradition. They say the district court's recognition of an unenumerated fundamental right to a climate system capable of sustaining human life squarely contradicts that directive, because such a purported right is entirely without basis in this nation's history or tradition. Absolute criminal nonsense. The government's lawyer makes a direct contradiction to the Ninth Amendment of the Bill of Rights of the American Constitution. What the lawyers for the government are saying, because the founding fathers of the Constitution of the United States did not stipulate specific rights to a safe climate, that the Constitution doesn't cover that. The government lawyers at the same time are totally rejecting the Fifth and the Ninth Amendments to the Constitution, which are in the Bill of Rights. Now, there's an interesting part in the government brief on its what it says about the original district court. Judge Aiken in 2016 finding for the plaintiffs, the young people. So it says the district court determined that it could redress those injuries by ordering defendants to cease their permitting, authorizing, and subsidizing of fossil fuels, and instead move swiftly to phase out CO2 emissions, including to develop a national plan to restore Earth's energy balance and implement that national plan so as to stabilize the climate system. The Attorney General's lawyer goes on, in its summary judgment order, the district court contemplates some of the actions that the government could take to redress the plaintiffs' asserted injuries, including drastic measures. Climate change is the drastic measure. Drastic measures like phasing out greenhouse gas emissions within several decades, and converting the nation's entire electricity generation infrastructure to 100% clean, renewable wind, water, and sunlight sources. Now, the science is absolutely definite that we have to phase out greenhouse gas emissions. Carbon dioxide has to be reduced to nearly zero, so said the IPCC 2014 assessment, and it had to reach net zero by 2050, so the IPCC last year 1.5 degrees C special report said. And that requires, obviously, and the world can readily do this, as we all know, 100% clean, renewable and everlasting, non-polluting energy sources, which we have many in great abundance. The lawyer for the Attorney General's office goes on, with respect to the government's affirmative acts, the court found the following chain to be sufficient. So this is what Judge Aiken concluded in her finding. Fossil fuel combustion accounts for the lion's share of greenhouse gas emissions produced in the United States. Defendants have the power to increase or decrease those emissions, and defendants use that power to engage in a variety of activities that actively cause and promote higher levels of fossil fuel combustion. That is totally obvious. The Attorney General's lawyer goes on to say that simply observing that the government has the power to take action does not establish that the government, as opposed to third-party producers and consumers not before the court, has actually caused climate change. It is an indisputable fact that the United States is a major source of carbon dioxide emissions and cause of global climate change. What we're looking at here is the Trump administration's national energy policy called an America First Energy Plan. The policy says that sound energy policies begin with the recognition that we have vast untapped domestic energy reserves right here in America, and this is referring to fossil fuels. The Trump administration will embrace the shale oil and gas revolution. We must take advantage of the estimated $50 trillion in untapped shale, oil, and natural gas reserves, especially those on federal lands. And the next paragraph, the Trump administration is also committed to clean coal technology, an oxymoron if ever there was one, and to reviving America's coal industry. So there you have it. Oil, natural gas, and coal. All of the fossil fuel energy sources which America, under the present government, is going to extract more and more and more, and they will be burnt, releasing more and more and more carbon dioxide emissions into the atmosphere, causing more and more and more global climate disruption and ocean acidification. That makes this American government national energy plan a global death sentence and a great unprecedented evil. Now, I don't use the term evil lightly because, like most people, it's not a term that I use. But this case is different. This is the unprecedented evil of the United States national plan to intentionally maximize the extraction of fossil fuels for energy production. There is no question that the continued increase, let alone the acceleration of atmospheric greenhouse gases, global warming, ocean heating, and ocean acidification from carbon dioxide emissions will cause an unprecedented degree of suffering and death to the future of humanity and the very survival of the human race. So this clearly, to me, is an appropriate use of the term evil ethically. But I do know as well that in the United States law, this term is used and used appropriately, as in this very recent case in March 2019 of the United States Supreme Court. This graph is the record of United States energy-related carbon dioxide emissions. Emissions are in million metric tons of carbon dioxide, and it starts in 1990, and it is up to 2018. So what is immediately obvious is there is a very big sudden increase in CO2 emissions from the United States 2017, 2018, and that's no big surprise because of the Trump administration American energy plan. But also please note that since 1992, the United States emissions have always been above the 1990 level. With the Trump administration energy plan, we can be certain that this rate of CO2 emissions, this increase, is going to continue. Now, with respect to this very rapid increase, which is going to continue into the future, of United States carbon dioxide emissions under the American fossil fuel energy plan, we do need to have a look at the most basic science of carbon dioxide and climate change, and that is that CO2 emissions last practically forever in the atmosphere. This is a quote from the IPCC, Intergovernmental Panel on Climate Change, 2014 Fifth Assessment. I was an expert reviewer of that. The removal of human-emitted CO2 from the atmosphere by natural processes will take a few 100,000 years. High confidence. It's going to take hundreds of thousands of years to remove the carbon dioxide, which is being emitted at an astounding rate and filling up the atmosphere at an accelerating rate. Continuing the quote, depending on the emissions scenario considered, about 15 to 40% of emitted CO2 will remain in the atmosphere longer than 1,000 years. We're presently tracking very close to the worst case scenario. So we're definitely looking at 40% of all the carbon dioxide being emitted remaining in the atmosphere longer than 1,000 years, continuing to heat the planet and acidify the oceans. This very long time required by the sinks, that's the natural removal, to remove anthropogenic, that's human-sourced CO2, makes, and here's the big IPCC quote, climate change caused by elevated CO2 irreversible on the human timescale. So carbon dioxide emissions last practically forever and they are irreversible. That means this. The global heating, global climate disruption, extreme weather events, and ocean acidification are all accelerating. And under the U.S. energy plan will continue to accelerate faster and faster. The only result will be accelerating the frequency and severity of heat waves, forest fires, droughts, superstorms, and floods, ruining life-supporting services, ruining food crops, collapsing world agriculture. The result of all this is an unlivable planet in a matter of decades. That is a future of a life not worth living for today's children and youth. By the end of the century, this future will be an uninhabitable planet. That's the trend that the world has been put on, particularly by the United States fossil fuel energy plan and policies. Now, I've already referred to the Trump energy plan as being a global death sentence, and it is. And it is an unprecedented evil. This United States national plan to intentionally maximize the extraction of fossil fuels for energy production is an unprecedented evil. No question with regards to any standard of morality and ethics. Now, here's the interesting thing on this word. I happen to have discovered in my research and reading that this term is used in the United States as a legal term. It's used and applied in the courts. And here's a very recent one, example, March of 2019, and this is a Supreme Court case, and the word evil is used to describe racial bias of particular populations. Well, we're looking at a particular population in this case. We're looking at all the children in the United States and all the children around the world. And this means that the intentional maximizing by the United States government of fossil fuel extraction and its fossil fuel emissions is an obvious manifest evil. And then there are fossil fuel subsidies. The U.S. has consistently subsidized its fossil fuel industries by a large amount. This is from the Natural Resources Defense Council, an article, Time for the U.S. to End Fossil Fuel Subsidies, of June 2018. A study on the G7 fossil fuel subsidies measured the U.S. against other G7 countries on each country's progress eliminating fossil fuel subsidies, and the United States ranked worst out of all the G7 countries. A recent 2019 publication by the International Monetary Fund found that subsidies for coal, oil, and gas in the United States reached a massive $649 billion in 2015. Subsidizing the fossil fuel industry today is a terrible evil, and it's particularly evil against all of American children and young people. They are being discriminated against in the most terrible way. The lawyer for the government in this case has said as much. So the lawyer says, no one disputes that the issue here is global climate change, summarizing undisputed facts in this matter concerning global impacts of climate change. So once again, the government side is acknowledging that global climate change is real, and it really has a number of serious global impacts on the global environment and on populations. He goes on, plaintiff's declarations, so this is, he's referring to the case of Our Children's Trust, likewise are clear on this point. One of their experts explained that the risks from climate change to some extent will affect everybody. Some groups are especially vulnerable, and children comprise one such group. So surely, on a common sense basis, you would have to think that the government's lawyer has proven the case for our children's trust. This next part of the paragraph follows. Indeed, the very concept of global warming seems inconsistent with the particularization requirement, because global warming is a phenomenon harmful to humanity at large. I don't understand what this particularization requirement is. Well, it certainly will be harmful to humanity at large, but the fact is, as he's acknowledged, that children are a particularly vulnerable subgroup, and this is how the science describes the vulnerability of children. And I do know that children are particularly vulnerable to every single impact of global climate change. And I'd invite you to look up the impacts, and you'll immediately see that children are particularly vulnerable. In other words, they're going to be particularly severely impacted by global climate change. I leave the final words for this video to the EPA, to the Environmental Protection Agency 10 years ago, its endangerment finding for greenhouse gases of 2009. In the document, we find this: emissions from wildfires can contribute to acute and chronic illnesses of the respiratory system, particularly in children. My emphasis, there's that particular requirement, including pneumonia, upper respiratory tract diseases, asthma, and chronic obstructive pulmonary disease. The IPCC reported with high confidence that in North America, disturbances like wildfires are increasing and are likely to intensify in a warmer future. And this short passage, finally, the administrator places weight on the fact that certain groups, including children, are most vulnerable to these climate-related health effects.